Magruder's American Government. Chapter 21, Civil Rights, Equal Justice Under Law. Section 4, American Citizenship. Citizenship is the badge of membership in a political society. Today, every state in the world has rules by which citizenship is determined, and much can be learned about the basic nature of a government by examining those rules. Who are and who may become citizens? Who are excluded from citizenship, and why? The Constitution and citizenship. An American citizen is one who owes allegiance to the United States and is entitled to both protection and to its protection and the privileges of its laws. As it was originally written, the Constitution referred to both citizens of the United States and citizens of the states. Neither of those phrases was defined, however. Throughout much of our earlier history, it was generally agreed that national citizenship followed that of the states. That is, a person who was a citizen of, say, Maryland was also thought to be a citizen of the United States. Actually, the question was of little importance before the 1860s. Much of the population was the product of recent immigration, and little distinction was made between citizens and those who were not. The Civil War and the adoption of the 13th Amendment in 1865 raised the need for a constitutional definition, however. The 14th Amendment met that need in 1868. From the Constitution. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. 14th Amendment, Section 1. Thus, the Constitution declares that a person may become an American citizen in either of two ways, by birth or by naturalization. The feature on page 634 summarizes the means by which American citizenship can be acquired. Citizenship by birth. Some 270 million Americans, nearly 90%, are citizens simply because they were born in this country. Another several million are also citizens by birth, although they were born outside the United States. Two basic rules determine citizenship at birth: jus soli and jus sanguinis. According to jus soli, the law of the soil, citizenship is determined by place of birth, by where one is born. Notice that the 14th Amendment awards American citizenship according to the location of one's birth. All persons born in the United States. Congress has defined the United States to include, for purposes of citizenship, the 50 states, the District of Columbia, Puerto Rico, Guam, the Virgin Islands, and the Northern Mariana Islands, and all American embassies and all public vessels of the United States, wherever they might be. Just how broad the 14th Amendment statement of jus soli can be seen from a leading case of citizenship, United States v. Wong Kim Ark, 1898. Wong Kim Ark was born in San Francisco in 1873 to parents who were citizens of China. He made a brief trip to China in 1895. Upon Wong Kim Ark's return, he was refused entry to the United States by immigration officials at San Francisco. They insisted that the 14th Amendment should not be read so literally as to mean that he had become an American citizen at birth. They declared that he was an alien and so was denied entry by the Chinese Exclusion Act of 1882. The Supreme Court held, however, that under the clear wording of the 14th Amendment, he was intended a native-born citizen of this country, and so not subject to the terms of the Chinese Exclusion Act. A very small number of persons who are born physically in the United States do not, in fact, become citizens at birth. They are those few who are born not subject to the jurisdiction of the United States, for example, children born to foreign diplomatic officials. According to jus sanguinis, the law of the blood, citizenship at birth may also be determined by parentage, to whom one is born. Thus, it is altogether possible for one to become a citizen at birth, even when that birth occurs outside the United States. A child born abroad can become a citizen at birth under circumstances set out in the feature on page 634. The 14th Amendment does not provide for jus sanguinis. However, Congress first recognized the doctrine in 1790, and its constitutionality has never been challenged. Citizenship by naturalization. Naturalization is the legal process by which a person can become a citizen of another country at some time after birth. Congress has the exclusive power to provide for naturalization. No state may do so. Individual naturalization. Naturalization is most often an individual process conducted by a court. Generally, any person eligible to enter the United States as an immigrant may become a naturalized citizen. Hundreds of thousands of aliens are now naturalized each year. An alien is a citizen of a foreign state who lives in this country. The U.S. Citizenship and Immigration Service in the Department of Homeland Security investigates each applicant and then reports its findings to the judge, with whom a petition for naturalization has been filed. If the judge is satisfied, an oath or affirmation of citizenship is administered in open court. Collective naturalization. At various times, entire groups have been naturalized en masse. This has most often happened when the United States has acquired new territory. Those living in the areas involved were naturalized by a treaty or by an act of a joint resolution passed by Congress. The largest single instance of collective naturalization came with the ratification of the 14th Amendment, however. The most recent instance occurred in 1977, when Congress gave citizenship to more than 16,000 native-born residents of the Northern Mariana Islands. Loss of citizenship. Although it rarely happens, every American citizen, whether native-born or naturalized, has the right to renounce or voluntarily abandon his or her citizenship. Expatriation is the legal process by which a loss of citizenship occurs. The Supreme Court has several times held that the Constitution prohibits automatic expatriation. That is, Congress cannot take away a person's citizenship for something he or she has done. Thus, actions such as committing a crime, voting in a foreign election, or serving in the armed forces of another country are not grounds for automatic expatriation. Naturalized citizens can lose their citizenship involuntarily. However, this process, denaturalization, can occur only by court order and only after it has been shown that the person became an American citizen by fraud or deception. A person can neither gain nor lose American citizenship by marriage. The only significant effect that marriage has is to shorten the time required for the naturalization of an alien who marries an American citizen. A nation of immigrants. We are a nation of immigrants. Except for Native Americans, and even they may be descendants of earlier immigrants, all of us have come here from abroad or are descended from those who did. Regulation of immigration. Congress has the exclusive power to regulate the crossing of this nation's borders, both inward, immigration, and outward, emigration. It alone has the power to decide who may be admitted to this country and under what conditions. In an early leading case on the point, the court ruled that the power of the United States to exclude aliens from its territory is not open to controversy. Che Chan Ping v. United States, 1889. The states have no power in the field. The passenger cases, 1849. There were only some 2.5 million people in the United States when independence was declared in 1776. Since then, the population has grown more than 100-fold to well over 300 million today. That extraordinary population growth has come from two sources, births and immigration. Some 70 million immigrants have come here since 1820, the year when such figures were first recorded. Congress made no serious attempt to regulate immigration for more than a century after independence. As long as land was plentiful and expanding industry demanded more and still more workers, immigration was actively encouraged. By 1890, however, the open frontier was a thing of the past, and labor was no longer in short supply. Then, too, the major source of immigration had shifted. Until the 1880s, more immigrants had come from countries of Northern and Western Europe. The new immigration from the 1880s onward came mostly from Southern and Eastern Europe. All these factors combined to bring major changes to the traditional policy of encouraging immigration. Ultimately, the policy was reversed. Congress placed the first major restrictions on immigration with the passage of the Chinese Exclusion Act in 1882. At the same time, it barred the entry of convicts, lunatics, paupers, and others likely to become a public charge. Over the next several years, a long list of undesirables was added to the law. Thus, contract laborers were excluded in 1885, immoral persons and anarchists in 1903, and illiterates in 1917. By 1920, more than 30 groups were denied admission on the basis of personal traits. The tide of newcomers continued to mount, however. In the 10 years from 1905 through 1914, an average of more than 1 million persons, most of them from Southern and Eastern Europe, came to this country each year. Quotas. Congress responded to pressure for tighter regulations by adding quantitative limits, numerical ceilings, on the qualitative restrictions, personal characteristics, already in place. The Immigration Acts of 1921 and 1924 and the National Origins Act of 1929 assigned each country in Europe a quota, a limit on the number of immigrants who could enter the United States from that country each year. Altogether, only 150,000 quota immigrants could be admitted in any one year. The quotas were purposely drawn to favor Northern and Western Europe. The quota system was not applied to the Western Hemisphere, but immigration from Asia, Africa, and elsewhere was generally prohibited. In 1952, Congress passed yet another basic law, the Immigration and Nationality Act. That statute modified the quota system, extending it to include every country outside the Western Hemisphere. Congress finally eliminated the country-based quota system in the Immigration Act of 1965. That law allowed as many as 270,000 immigrants to enter the United States each year, without regard to race, nationality, or country of origin. The 1965 law gave special preference to immediate relatives of American citizens or of aliens legally residing in this country. Present immigration policies. Today, the Immigration Act of 1990 governs the admission of aliens to the United States. Like its predecessors, it was adopted only after years of intense debate, and many of its provisions are the subject of continuing controversy. The 1990 law provided for the substantial increase in the number of immigrants who may enter the United States each year. The annual ceiling is now at 675,000. It also continues the family preference policy first put in place in 1965. At least 1/3 of those persons admitted under its terms must be the close relatives of either American citizens or resident aliens. Those immigrants who have occupational talents which are in short supply in the United States, notably highly skilled researchers, engineers, and scientists, also receive special preferences. Only those aliens who can qualify for citizenship can be admitted as immigrants. The law's list of excludable aliens, those barred because of some personal characteristic, is extensive. Among those excluded are criminals, including suspected terrorists, persons with communicable diseases, drug abusers and addicts, illiterates, and mentally disturbed persons who might pose a threat to the safety of others. Some 53 million persons, non-immigrants, come here each year for temporary stays. They are mostly tourists, students, and people traveling for business reasons. Deportation. Most of the civil rights set out in the Constitution are guaranteed to persons, a term that covers aliens as well as citizens. In one important respect, however, the status of aliens is altogether unlike that of citizens. Aliens may be subjected to deportation, a legal process by which aliens are legally required to leave the country. The Supreme Court has long held that the United States has the same, almost unlimited power to deport aliens as it has to exclude them. In an early major case, the court ruled that deportation is an inherent power arising out of the sovereignty of the United States, and that deportation is not criminal punishment, and so does not require a criminal trial. Fong Yue Ting v. United States, 1893. An alien may be deported for any one of several grounds. The most common is illegal entry. Thousands of aliens who enter with false papers, sneak in by ship or plane, or slip across the border at night are caught each year and deported. Many of them are repeat offenders who will soon make yet another attempt to cross the border. Conviction of any serious crime, federal or state, usually leads to a deportation order. In recent years, several thousand aliens have been expelled on the basis of their criminal records, especially narcotics violators. The war on terrorism has also quickened the pace of deportations. Because deportation is a civil, not a criminal matter, several constitutional safeguards do not apply. For example, bail and the ban on ex post facto laws. Undocumented aliens. No one knows just how many undocumented aliens reside in the United States today. Their numbers began rising in the 1980s, and best estimates by the Department of Homeland Security and other sources put their total today at about 11.5 million. Most enter the country by slipping across the Mexican or Canadian borders, usually at night. Some come with forged papers. Many others are aliens who enter legally as non-immigrants, but then overstay their legal welcomes. Well over half of all aliens who are here illegally have come from Mexico. Most of the others come from other Latin American countries and from Asia. A majority of the Mexicans stay here only some 4 to 6 months a year, working on farms or in other seasonal jobs, and then return home. Most others hope to remain here permanently. A troublesome situation. Over here, many of these aliens find it easy to become invisible, especially in larger cities. The law enforcement agencies find it very difficult to locate them. Even so, immigration officials have apprehended more than 1 million undocumented aliens each year in the last several years. Nearly all are sent home. Most go voluntarily, but some leave only as the result of formal deportation proceedings. The presence of so many undocumented persons has caused a number of nagging problems. Those problems have grown worse over the past several years, and, until recently, not much had been done to solve them. Consider this. Ever since 1987, it has become illegal for an employer to hire an undocumented alien to perform work anywhere in the United States. Even so, some 8 million persons who now hold jobs in this country came here illegally. Some employers still hire aliens who are often willing to work for substandard wages and in substandard conditions. No one knows just how many undocumented aliens have taken jobs on farms or become day laborers, or how many have become janitors or dishwashers or seamstresses in sweatshops, or have found other menial work. However many they are, their presence has multiplied the burdens of an already strained public school system and welfare services of an increasing number of states, most notably California, Arizona, Texas, and Florida. Current law. The problems posed by undocumented aliens trouble and divide many different interests in American politics, chief among them labor, farm, business, religious, ethnic, and civil rights organizations. After wrestling with the matter for years, Congress was finally able to pass the Immigration Reform and Control Act of 1986. Then it enacted the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. The 1986 law did two major things. First, it established a 1-year amnesty program under which many undocumented aliens could become legal residents. More than 2 million aliens used the program to legalize their status. Second, that law made it a crime to hire any person who is in this country illegally. Any employer who knowingly hires an undocumented alien can be fined from $250 to as much as $10,000. Repeat offenders can be jailed for up to 6 months. The 1996 law made it easier to deport illegal aliens by streamlining the deportation process. It also toughened the penalties for smuggling aliens into this country and prevented undocumented aliens from claiming Social Security or public housing benefits. The statute also doubled the size of the Border Patrol, which is, today, the largest of several federal law enforcement agencies. Congress has not been able to enact any meaningful immigration reform legislation for some 2 decades now, however. The principal reason for this impasse is a continuing dispute over how to approach the matter. Many insist that stemming the flow of illegal entries should be the nation's first concern. Others argue that the nation must confront the problems posed by the undocumented aliens already in this country. They want to make it possible for those undocumented aliens to become legal residents and, eventually, citizens of the United States. In 2012, President Obama, frustrated by a lack of congressional action, issued an executive order that suspended deportations of children of illegal immigrants for 2 years, noting that this is a temporary stopgap measure. The president urged Congress to act to pass permanent immigration reform legislation.